Can wrongful death cases in California be settled through mediation? Attorney Ben Glen explains that wrongful death cases may be settled through mediation. Mediation is a form of alternative dispute resolution where the parties agree to attempt to work out a settlement through the use of a mediator, a person who usually has a great deal of legal experience through being a lawyer or a retired judge. After reading all the claimants' and defendants' attorneys' briefs, written descriptions of the case, including facts, liability, causation, and damages, among other things, the mediator discusses the case with the parties either altogether or separately, depending on the parties' preferences. The mediator then performs shuttle diplomacy, going back and forth between the parties, discussing the relative strengths and weaknesses of each claimant's claim and the defendant's defenses to establish a footing for taking the case further, so as to all offers to be made, which usually lead to counteroffers and ultimately an agreement to settle the case. However, that process can vary widely depending on the case, from just a matter of half a day or a day, multiple days, multiple weeks, or even months, with multiple sessions. There are other methods of alternative dispute resolution, such as arbitration, or an arbitrator, essentially acting as a judge, is agreed upon by all parties to make a decision as to how to split the proceeds between the claimants. The decision may be binding or non-binding, depending on the party's preference. If binding, the decision is usually final, except in rare cases. If non-binding, the arbitration decision can be rejected by any party without giving a reason, and the case continues towards trial, but may be settled through mutual resolution between the parties and their attorneys or mediators. For a free phone consultation, contact Attorney Ben Glen in California at 877-236-4536 or visit www.gleninjurylaw.com.